Commissioner Campion.
Okay, all right. So the request was to waive the one-year res judicata requirement, which would have required these particular developments to wait until, I believe it was October, to reapply if they wanted to reapply. The changed circumstances, as I perceive them, is the acquisition of additional right-of-way that would allow the connection of the parcels that were referenced as the Goose Prairie parcels, or Goose, did I say the wrong? Did I say Goose Creek or Creek? Goose Prairie is on the other side of the road. All right. So the acquisition of right-of-way with additional land granted from Water Authority property that would actually bring Goose Creek Road to the Goose Creek property, thereby giving it a direct access to 44 and not requiring it to go over to Harbor Shores and further compound the problems that already exist on Harbor Shores Road. To me, the fact that that right-of-way could be acquired and used for that purpose is a substantial change in what we previously reviewed. Now, I can say until I look at what would be proposed and how it would be done and how it would be connected and what other improvements might be made to accommodate and address traffic concerns, I can't say whether I would vote in favor of it or not.
Right.
But if we don't review it now, we will be getting an application in October to review it based on these changed circumstances. So why not hear what it is that they're proposing to do, and to see, whether we would look at it differently or whether there are other things that we would want to require if it were to go forward. So we do know that after it was denied and during that discussion, I know I specifically brought up the fact that they had zoning already to do a development on all of that land. They already had the zoning. They were asking for a PUD. So I just wanted to point that out again. When the denial happened, they did in fact ask for dispute resolution, which is essentially litigation, asserting their rights against the county. So with that in mind, and knowing that they asserted their rights under litigation, number two, that they will be back in October, now that we have these changed circumstances, to me, it seems like it warrants us to relook at these cases.
No problem. Tara Tedrow, Lowndes Law, 215 North Eola Drive, Orlando, Florida. I'm going to be very brief, which is not typical for me, and I also don't have a PowerPoint, so this has nothing to do with the merits of the case. We're not going to go over the details of the site plan. All this is just to bring up that since October, when that hearing happened, and today, we both revised the site plans to change it from one access that put all traffic from two separate PUDs onto Harbor Shores Road to instead have them go to Goose Creek, to Eagle Point Court, and to Harbor Shores. The modification of those access points also triggered us running an updated traffic analysis in January. That analysis had previously been sent to your staff, and the analysis showed that a signal at Harbor Shores and 44 was no longer warranted, which was, again, one of the big points of contention at the last hearing. At that first hearing, those types of improvements weren't possible because there was a lack of right-of-way. Since then, in December of last year, there was a dedication by the Lake County Water Authority that dedicated 1.4 acres to provide for 60 feet of right-of-way to allow for that access point on Goose Creek. That right-of-way was actually dedicated specific to this project. So the ability to have a new access point, which provides for an alleviation of some access issues and transportation deficiencies for the Shangri-La residents, as well as allowing for better emergency accessibility back to that area. And again, those are some significant changes to the plans that we had before. We've rerun the numbers on the transportation analysis accordingly, and we would appreciate the opportunity not only to bring this back before you at a public hearing so we can fully vet out the details of these revised plans, but also, as Vance noted, I do like community meetings. So the folks that are here and then anybody within 500 feet of the property will be getting a notice that we're going to hold a community meeting on the 24th to present the plan in advance of coming back before you, probably regardless of whether we come back before you, because we do want to present that updated plan in anticipation of the fact that it's going to come back one way or another. So the transportation deficiencies and concerns seem to be the number one most vocal point of opposition during those October denial hearings. I know there were some other issues that we can address before you more fully at another hearing, but those significant change in circumstances on access, removing a signalized intersection, again, providing better emergency access, dedication of right-of-way, all were significant enough and would certainly meet case law thresholds for being able to bring this back under your new ordinance 2023-18 for res judicata.
Okay, thank you.
Answering my question on the safety issue, the only thing that I think it just keeps getting lost in all of this, if nothing happens today, if there was no dedication or an ultimate dedication of some of the water authority land for public right-of-way, not dedicated to a developer, but for public right-of-way, these properties already are zoned for residential. These properties can already be developed no matter what we do. And if that happens, they use Forest Lake, they go to Harbor Shores, they come out to 44. So that is reality. So if we as a board looking out for the public interest get an opportunity to actually make it so that there can be a way for additional access, primarily just for EMS and first responders, secondary for people that are coming and going from their homes, that to me is a changed circumstance I think is worth looking at.
So we're going to close the discussion to the public and bring it back to the board. All right, commissioners?
Yeah, I'll just go ahead and say, I understand both sides here, and I do think that there'll hopefully be some compromise going forward, because whether we hear it, decide today to rehear it in the next, I would hope would be June or in October, it sounds like apparently it's going to be coming in front of us again. So I would hope that there would be some compromise. I think in talking with some of you that there would be. There's an understanding there, and hopefully on this side there would be as well. I don't support it moving forward today. I understand. I couldn't fault somebody that would determine that this would be significant. Primarily because that's why I opposed that dedication. When did we do this? A couple months ago? Whenever it was. I opposed it then with the Water Authority because I did view it, as I had heard, as primarily just a move to get access for this development. So I opposed it then. So I'm going to be consistent, and if that's the only change that I'm hearing, and we're sort of we're in a conundrum because maybe there is going to be significant changes, but without hearing their site plan and everything else that's being proposed that's new, based off of just solely that one new access point, it's just my interpretation, especially being consistent with how I opposed it to begin with several months ago, that I wouldn't support it today. If it does go forward, I'd ask that you hear it in June, at least. It gives them a little bit of time to,
Okay.
Yeah.
All right, Commissioner, nothing? All right, so I'm more of a by the book kind of guy. So I think there's enough evidence here for significant change. I want to see what all they have planned. They are the developers are over there. They heard your concerns about no community discussions. I believe that their attorney said that they were going to have a meeting on the 24th or something. Is that right? Of what month? Yeah. Okay. So April 24th. I'm sure that she will not leave before y'all can talk to her to find out where that meeting is going to be. So hopefully the communication will be there. But For today and for this item is just if there's significant enough change to bring it back so we can look at what all they changed, basically. So with that, bring it back to the board.
I'll just concur, yeah. I mean, I think an additional access point does constitute significant change.
And I've already stated that I think having another access point constitutes change. I do want to point out, too, that at the time the Water Authority was considering this, they also had a case very similar over in the Okahumpka area, where there was an easement that was in place in order to kind of open up a property owner's property, which did, in fact, facilitate development, but the property was going to be developed no matter what. It just would have impeded it. And they voted in favor of releasing an easement. There were some trade-offs there, just like they negotiated some trade-offs here to make it this conservation land accessible for maybe future trails and things like that. So it was, to me, those were very similar situations where, yes, you've got a public easement or you have public land, but it serves a public purpose in order to actually do a dedication or do a release. And so that's why I thought it made sense at the time. To the question of whether there's a substantial change that would warrant us actually using the res judicata clause provision in order to hear it again, it meets that criteria. So we, as Commissioner Smith said, that'll be the developer's opportunity to present any other information about their projects, any changes that they might make, or any responses or changes they make to feedback they receive from the community. So I'm really hopeful the community meeting and the offer by the developer is an opportunity for both parties to get together and come up with something that I think everybody talked about, compromise, things that address issues. Maybe we can get the school bus issue addressed, things like that. So with that being said, I would, did you make the motion? Okay, I'll make the motion to hear the case, again, according to the res judicata provisions.
And I'll second.
Just quick
Okay.
discussion.
So we have a motion and a second. We're now in discussion.
Just also want to add, since this might be litigious, or maybe it already is, I would also like to add another point from my opposition that I did agree with. I'm not sure who made the statement that they should be separated. I think this, if you were to interpret this as a significant change, it would be to the Goose Creek, that development, but not the harbor shores as well. So just on the record that I agree with that statement as well.
Okay, and I disagree with that, because if you didn't have this other change, then everything would be going back onto Harbor Shore. So it's a significant change for both of them, in my opinion.
I know, I appreciate you putting that on the record, because I think that's, once you have a secondary access or a primary for one parcel and a primary for the other, you've impacted both of them.
Correct.
The circumstances have changed for both of them.
Yeah, and I'm on the record for why I don't
Okay,
think it's...
so, all right, we have a motion and a second. Any further discussion?
Mr. Chairman, Mr. Chairman, a voice from anywhere, right? Can we clarify if we're going to bring this back May 2nd or June 6th, please?
I'm not sure the applicant care about June 6th.
I think when we had previously discussed this with Melanie's office, we were anticipating it coming back on the next hearing in May. If it's a discussion point with the board and a preference for one hearing, of course, we'll defer, but to what your decision is.
Okay,
But I think May was what we had originally discussed.
and you're having a meeting with the community in April 24th? Yeah,
I think June.
I think June would be good.
Yeah, I think
June
June
would be
makes
good.
more sense.
Yeah.
Yeah.
Okay, that would be the first meeting in June, June 6th, and that'd give them plenty of time to talk to the developers and so, okay. So we have a motion and a second. Any further discussion? All those in favor say aye. Aye. Opposed?
Aye.
Opposed.
Yeah. Motion carries 3-2.